What's the last nga itong i-discuss? Anybody? I guess, since nobody answers that question, I guess I suppose we end up our discussion on the administrative power of the president. Okay, so take note of the structure, basic structure of the Philippine government. Okay, we have the executive, legislative, and judicial power. Okay, so for administrative, we only focus on the executive power of the president. The president exercises control on the national government, but as to the local government, the power of the president is only up to supervision. So take note of that. What's the difference between those two terms? Okay, going back, the president's powers are vested in the executive powers vested in the president of the Philippines. So it's the president who will execute the laws passed by Congress and the Constitution. Okay, the president shall have control over its executive departments, bureaus, and offices. So you know what's the meaning of control, right? He may modify, nullify, set aside what the subordinates or officer had done in the performance of their duties, and to substitute the judgment of the former for test of the latter. So whatever decision of the executive heads, let us say the department secretaries, the the bureau departments, like the bureaus, the offices may be nullified, set aside, or modified by the president. That is control. Whereas in supervision, which is also found in the local government units, the president doesn't have control, but only supervision. And what is supervision? It's an overseeing or the power or authority of the officer to see that subordinates officers perform their duties. But as to how the subordinate officer performs it, like the governor, the mayor, as to how they perform it, that's not the duty of the president anymore, because his power is only supervision. Okay, so and the meaning of supervision is to see to it that the law is carried, but as to how they carried it, that's not the duty of the president anymore. Okay, because as to if the president supersede, modify, nullify, set aside the judgment of the local chief executive, that is already control, which is not the power of the president over local government units. Now, so how about the congressional oversight power? What is that congressional oversight power? Congress uses oversight power to make sure that the administrative agency perform their functions within the authority delegated to them. So there are three characteristics of a congressional oversight functions. It's actually a committee, okay, created to see to it that laws are faithfully executed. They may call anybody, including those administrative agency under the executive branch. For what? One is for scrutiny. What is scrutiny? The passive process of looking at readily available facts. Okay, Congress may request information, okay, and report from the other branches of government. It can give a recommendation or pass a resolution, okay, for consideration of the agency involved. Okay, so of course you know the different branches, right? The congressional belongs to legislative branch, but they may call anybody, including the executive branch, to report, okay, or to be scrutinized for them to make a law, or if, let us say, if there is a problem um, in the implementation of the law, they can call so that they can make laws. Okay, that is first the rule of that's one category or function of the oversight committee. Then we go to the second. which is second category of the oversight function. Investigation involves a more intense digging of facts, and the power of Congress to conduct investigation is recognized by the 1987 Constitution that the Senate and the House or any of its representatives respective committee may conduct inquiries in aid of legislation. So if there's a problem that may arise, they can call anybody, including the executive branch, to appear only for investigation so that there will be a possible passage of a law in order to solve a problem. Okay, so of course you've heard in the news countless times they call on different secretary, okay, in aid of legislation if there is a problem. But sometimes the president, if the information would implicate the president, may not even allow different secretary to be there. Okay, and what we call that power. If it's not found in any other powers discussed in the found in the in the Constitution, we call it as a residual power. Okay, so in the case of Arroyo, one of her secretary was summoned upon by the Congress to shed light of a problem. I think that was in Hilo Garci. Okay, the president called one of the COMELEC to on alleged malpractice in election, but the president did not allow certain officers to be there, and there was a question whether the president allows or whether the president is or has the power not not to allow them to be present during a congressional inquiry. Okay, so it is allowed because the president also has a residual power. A residual powers, any other powers which is not vested in the Constitution, by the fact that he or she is the president, he has other powers. Okay, that's the meaning of a residual power. Now we go to supervision. What is supervision? Connotes a continuing and informed awareness on the part of a congressional committee regarding the executive operations in a given administrative area. It allows Congress to scrutinize an exercise of a delegated law-making authority and permits Congress to retain part of that delegated authority. So, as you know, the Congress has a delegated power. Okay, so still they have the supervision over executive branch. So they still have a power over executive branch. Okay, this is so confusing. Why? Because Congress belongs to the legislative branch, but the implementers are the executive branch. But the supervision still may be exercised by the legislative branch through Congress, okay, because they have the delegated power. Okay, it allows Congress to scrutinize the exercise of a delegated lawmaking authority and permits Congress to retain part of that delegated authority, okay, because they have delegated powers. Okay, so still they still remain a power of Congress to scrutinize even those belonging to the executive branch. A legislative veto is a statutory provision requiring the president or an administrative agency to present the proposed implementing rules and regulations of a law to Congress, which by its thorough committee formed by it retains the right and power to approve or disapprove such regulations before they take effect. As such, a legislative veto is a form of congressional oversight committee. So, meaning, if the law passed by Congress is not clear, the executive branch may pass what we call the implementing rules and regulations. But that implementing rules and regulation actually comes from Congress because they are the one who makes the law. But the law, if that's clear, it's the executive branch. So, but as to how it should be implemented, they still have the power, okay, to approve or disapprove the regulations. To simplify, the legislative branch makes the law. It will be implemented by the executive branch. If the law they pass is not clear, example, IETF, Bayanihan Act is not clear, right? That there will be um, monetary consideration given to those who will be a victim of COVID. But we do not know who are those people will benefit, or if there's if the law is clear, or if it will be implemented right away, then there will be no more question anymore. But since there are many questions, then there will be an implementing rules. If the implementing rules is not clear, then there's a time that the Congress, because the law comes from them, has the right and power to approve or disapprove such implementing rules and regulation before they take effect. Okay? So we call it as the legislative veto, a form of congressional oversight committee. Okay? Is in the form of inward turning delegation designed to attach a congressional leash other than a thorough scrutiny or investigation to an agency which Congress has by law initially delegated broad powers. Okay, the law must be very specific, otherwise that law has cannot be effective they're being broad. Okay, if it's broad enough, it cannot be implemented. Now, what is a judicial review? Okay, so courts can provide immediate relief, and also they differ to experts. If the law is silent, it does not mean that there is no judicial review. What do you mean by judicial review? If the law they pass is not clear, then it can be reviewed by the courts. So take note of the interagencies. Okay? We recall a while ago that there are three branches equal in power, but they cannot, generally, they cannot intervene, being an independent body. We have executive branch, legislative, and judiciary. They are equal in power. But, okay, in our example, the legislative branch may even exercise a little power over administrative body. Okay, if the law now that Congress passed is not clear, it may be reviewed by another branch, and that is the court in a form of a judicial review. In what way? For example, if the law may not may be violative of the constitutional right. Example, terrorism law. It might violate rights of the citizen. So it may be questioned in court. What we call it as a judicial review. So for questions of policy, the court will not interfere with the decision of the administrative agency. So take note, if it's only a matter of a policy, then the court will not intervene. Why? Because it is not within their power. But what is the power now of the court? Okay, for questions of discretion, the courts will also generally not interfere unless there is a grave abuse of discretion. Okay, so the only way for a court to intervene is when the law passed is attach a grave abuse of discretion. And what is a grave abuse of discretion? It is a bias, clearly or patently or obvious disregard of a law. Okay, grave abuse of discretion. Grave meaning it's beyond ordinary abuse of discretion. You have the right to decide for it, but it's already beyond. Okay, so that ground itself is subject to a judicial review. So take note of that. So you should know what are those decisions that are purely administrative agencies. Okay, and that is a question of policy. If it's a question of policy, then the court will not intervene. If it's a question of discretion, okay, meaning it is their judgment to grant it or not, the court will not intervene. But if that discretion is so grave, okay, there's a grave abuse of that discretion, okay, although patent, but still they decide otherwise, then the court will now intervene. So take note of that. It's very important. So when can it may be asked, when can the court um, intervene, or when is there a judicial review in administrative cases? Only when there is a grave abuse of discretion. Without a grave abuse of discretion, then the court will not intervene. Take note, why is it so? Oh, why is it that the court is so limited? Because that falls under another branch, and another branch should be respected. Okay, so many times the court will always respect the decision of the other department. Okay, so normally if the decision is so grave, then that's the only time that the court will intervene or take cognizance thereof. Other than that, the court will always respect the other branch. Now we go to the ombudsman. What is an ombudsman? The office of the ombudsman has the power to investigate and prosecute in its own or in complaint. Okay, so you've heard of an ombudsman, right? Even in our school, we have the ombudsman. Okay, what is the function of the ombudsman? Investigate, prosecute in its own, meaning motu proprio, or on complaint by another person, or when there is a complaint by another person. But normally, in my experience, okay, when I've heard many times from them, from the ombudsman, that they will not act on motu proprio. Why? Because it if they act on their own, they may lack evidence unless there's really a clear evidence showing of a violation of the law. Okay? But if they prosecute in their own, they find it difficult to look for evidence. Okay? That's why they cannot act, or if they act, they normally the case will be dismissed. Why? Because they lack evidence. Okay, except again if there is a complaint filed by a person. Why? Because that person will produce evidence. Okay? So it's easier if there's a complaint from a person, because that person will really provide the evidence. But not that the ombudsman will look for evidence to prosecute somebody. The ombudsman is a special prosecutor. Okay, it's not a court actually. They're just special prosecutor. They will bring the matter to the court. Okay, and these cases are cases over government employees. But if the salary grade is 27 and above, then it is the Sandigan Bayan. So ombudsman for lower salary grade of a government employee, higher than that it is the Sandigan Bayan. Now, so complaint of any person or any act or omission, act meaning it's an act, any action which result to a violation of a law, or omission, you did not perform anything, and yet you will be punished. Is there an omission that are punishable? Yes, there are many. Like for example, misfeasance, you did not perform the job as a government employee, then you will be charged by the ombudsman for omission. You did not perform anything, misfeasance or malfeasance or non-feasance. Okay, lack of performance, or you did not perform an act which is supposed to be done. Even in criminal law, omission is also punishable. Like for example, you've seen a victim of a a murder, um, attempted murder. He's still alive. Okay, he asked for help, but you did not. So that act of that omission, meaning not performing an act, in itself violative of the law. So you will still be punished for omission. Okay. So of any public officer or employee, a office or agency, when such acts or omission appears to be illegal, unjust, improper, or inefficient. Okay, this power has been held to include the investigating and prosecution of any crime committed by a public official, regardless of whether acts or omissions complained of are related to or connected with or arise from a performance of an official duty. It is enough that the act or omission was committed by a public official. Now, in the case of um, regent of the UP Diliman, okay, even a board of regent, a student board of regent who is not a public employee, as she claimed, okay, her name is Hannah, but she was considered as a public officer, okay, because and they were charged in the Sandigan Bayan. The case was entered into, there was a contract entered into, and the case, they were charged for corruption. Okay, and the case was, it reached in the Sandigan Bayan. The other person, the student, claimed that she's not a government employee. So therefore, she should not be charged in Ombudsman. But she's wrong. Why? Because if you are involved in a transaction, even if you are not a government employee, you will be considered as, you will be included. Okay? So even if you are not a government employee, you will be under, still you can be subject of of an ombudsman if you are part of the contract that deals with the government, or you are one of those government employees who transact with the government, and that transaction is illegal. Okay, now take note, in the Sandigan Bayan, even if you are not a salary grade 27, but as long as you perform a administrative or management position, then you can be charged in the, or by the Sandigan Bayan. Okay, so the word there is salary grade 27 or performing an administrative function. Now, so it is enough that the act of omission was committed by a public official. Okay, so what are the powers of the administrative agency? First, we have the quasi legislative or role making, quasi judicial or adjudicatory, function as a court, determinative powers, enabling powers, defines as, or it permits the doing of an act which the law undertake to regulate and which would be unlawful without the government's approval. Okay, issuance of a license to engage in a particular business or occupation. Example of a directing power: order the performance of a particular act to ensure compliance with the law and often exercised for corrective purposes. What about this fencing power? Allows the administrative officer to relax the general operation of the law or exempt from performance of a general duty. So they may also have that power, dispensing. You may be exempt from such performance of a law. Examining power enables the administrative body to inspect the records and premises and investigate the activities of persons or entities coming under its jurisdiction. Okay, summary powers, those involved use of administrative authorities to force upon persons or things without necessity of a previous judicial warrant. What does it mean? Can the administrative agency go and enter the house without warrant? Can they do that? Okay, those involve the use of administrative authorities to force upon persons or things without necessity of a previous judicial warrant. Can it be done? Can they do that? Okay, in the case of a custom, okay, they may go and, and expect only when it is within the customs premises or within the port, they can do that. Okay, they can even open a container branch even without warrant. Okay, because that fall under their administrative authorities to force upon persons or things without necessity of a previous judicial warrant, but only when it is within their premises. How about outside? They cannot do that. Why? Because they require warrant. Okay. Now, does the grant of such power to administrative agency violate the doctrine of separation of power? Okay, does the grant of such powers to administrative agencies violate the separation of powers? No. Administrative agencies became the catch basin for the residual powers of the three branches. Okay, so we defined a while ago what do you mean by residual power. Any other powers which are not defined, then this may be granted by the administrative or by the executive branch. Okay, administrative agencies became the catch basin of the residual powers of the three branches. The theory of the separation of powers is designed to forestall the overaction resulting from the concentration of power. However, the growing complexity of the modern life, there is a constantly growing tendency toward the delegation of a greater power by the legislature. After all, they are the representatives of the people and they are numerous compared to other branches where it's only vested in one person. Okay? So in case of a possible conflict, then Congress itself has the residual power, or the administrative agency has the residual power. We go to the role making power. Okay? So the authority delegated by the lawmaking body to the administrative agency to adopt rules and regulations intended to carry out the provisions of a law and implement a legislative policy. So again, if the law passed by Congress is not clear, then the administrative agency may make its own implementing rules and regulations based, of course, on the law passed by Congress. There are times when the law really is not really clear. After all, the law requires that it should only be brief, concise, and definite, or brief, concise, or just short. Okay? It cannot comprehend all, otherwise, it will take time for Congress to make such law. That's why the administrative agency has the power to pass and implementing rules and regulations based on the law passed by Congress. Okay? So this is an executive branch in charge in the implementation. So since they are the one who will implement, they are going to make it sure that the laws are clear. So they're going to make a implementing rules and regulations. Another, what do you mean by quasi-legislative or role-making power? Is the power to make rules and regulations that results in a delegated legislation that is within the confines and granting of the statute and the doctrine of non-delegability and separability of powers. Okay? So it's within their power granted to them by Congress, so they can make and implementing rules and regulation. Now, the granting of a role making is a relaxation of the separation of powers principle, is an exception of a non-delegation of a legislative power. General rule is that the power cannot be delegated, right? But the executive branch, through its administrative agencies, has the power to make rules and regulations based on the law passed by Congress. So Congress passed a law, but if it's not clear, it is the executive branch through its administrative agency to implement it. So they're going to make implementing rules and regulations. So it's a very long rules interpreting the law passed by Congress. It's very short, but the law passed by Congress very short, but when it's implemented, when there's an implementing rules and regulation, it's thicker. Okay, because it's more detailed. Now, so it's actually perhaps a violation, but the law relax it for Congress to make, for the administrative body to make implementing rules and regulations. Now, administrative regulations enacted by administrative agency to implement and interpret the law which they are entrusted to enforce have the force of a law and entitled to respect. Okay, so whatever the administrative agency implement or how they interpret it, that should be respected, even by courts, even by courts. Okay, so in fact, the civil service sometimes would remand the case to the administrative agency. Okay, because it's a prerogative of the administrative agency to interpret the law they created under that delegation of powers from the Congress. Such rules and regulation partake in the nature of a statute and are just binding as there have been written statute itself. Okay, so you should be, I should understand how it works. As such, they have the force and effect of a law and shall enjoy the presumption of constitutionality and legality until they are set aside with finality in the appropriate case by a competent court. Okay, so the administrative decision shall be respected by even by courts. So it is similar to a criminal case when a police officers perform its duty, they are presumed to be regular, or we call it as the presumption of regularity. Congress, in the guise of assuming the role of an overseer, may not pass upon the legality by subjecting them to its stamp of approval without disturbing the calculated balance of powers established by the Constitution. Okay, hence, legislative vetoes are unconstitutional. Okay, what do you mean by doctrine of subordinate legislation? The the power to promulgate rules and regulation is only limited to carrying out into effect what it is provided in the legislative enactment. Okay. Um, excuse me for a while. I have to